Next point is, what will our course reading? To develop your ability to write clear and correct any legal writings, it is necessary to review all laws which are associated with conveyancing, such as the Contract Act 1872, the Transfer of Property Act 1882, the Partnership Act 1932, Companies Act 1994, the Power of Attorney Act 1882, and also the Stamp Act 1899. As you are law students, and by considering the prerequisite of this course, I can believe that all of you are very much familiar with all these relevant laws. In addition, for further explanation, you can also use the books as I mentioned here. The books are Indian Conveyancing, Legal Drafting, or Legal Writing and Drafting. Any books you feel comfortable for them you can use. Now, in this particular course, we will pursue the different law topics. Sorry. Those are mostly associated with drafting or documentation. As you are law students, you need to learn laws and their application for doing documentation, which means the situation and act interaction. You need to know how can you write a legal document or a legal writings. In addition, it is very likely that your legal writings or draft will not be correct unless you have law in your mind. When you will think a situation and situation involve issues relating to law, that is very likely that someone who have pursued any kinds of drafting will never be giving a wrong decision in his or her legal writings. So, in this course, we will try to make easier to students to draft legal documents. I will make myself available for the students by consultation hour. I will bring the principles of different laws in a very reasonable manner in different videos. In addition, you students should remember it is conveyancing and legal writings course, and you will get a good chance to develop your ability by doing more practice or by writing more legal document, and discuss them together so that student can appreciate that what is law and how law involves in the different documentation. For this purpose, you will need to attend the quiz and other assignments, which is another way to examine yourself. Because there is no point of learning the different types of law unless you can help your knowledge or unless you can apply your knowledge in a particular situation or in a particular writings. Application of law or enforcement of law is the most important factor for your future work. Therefore, the learning outcomes associated with this course is to acquire and demonstrate a satisfactory understanding of all relevant topics such as partnership, contract, transfer of property, and other which is associated with the drafting. This knowledge will be acquired by attending lectures or listening to lectures, recordings, reading lecture materials, and reading the prescribed textbook. And to understand the nature of conveyancing is to appreciate how it calls upon various disparate areas of law. Convincing requires you to blend your knowledge and to understand fundamental concepts to determine the terms of different laws, and to acquire and demonstrate an ability to present substantive law in the context of pleading and convincing. Now I am going to discuss regarding our midterm syllabus. We'll start with the historical perspective of convincing and legal writings. After that, we'll look at the classification of different types of documents or legal instruments. Next, we will learn what are the basic principles of drafting. These are expression, design of the draft, precision of language, and communicability of intention. After that, we will learn what are the essential elements of a deed or a legal document or a legal instrument. There are three essential parts of a legal document. Those are the non-operative part, the operative part, and the formal part. We will see detail of these parts in our next videos. Next, we will discuss what are the conditions of completion of a deed. For this purpose, you students have to remember you will prepare a deed or a legal document or a legal instrument. You have to fulfill all the conditions or legal formalities for enforcing the specific deed as a valid deed. In addition, a legal instrument or deed shall not be a valid deed unless it is validly executed as a deed. Or on the other hand, you can explain when a document is validly executed by the parties as a deed if and only if it is duly executed by the parties. The conditions are attestation, stamp duty, registration. We will learn different laws which are associated with different issues relating to law. Finally, after all the theoretical aspects, we will learn how can we write the different documents or legal instruments. For example, legal notice and affidavit.